All right, welcome to another OpenChain webinar. This time we're talking AI once again. And once again, we have the team at GTC Law here to help us understand what's going on. Now, this has been a topic we've discussed a lot in the OpenChain community, and we were very fortunate last year to have the GTC Law team arrive and talk to us about some of the issues around generative AI. Today, a year later, we're going to talk about the current legal landscape, and that's a big conversation. So this time we have four speakers to help us take it on. Before we get started, I'm just showing the antitrust policy notice. We show this at the beginning of every Linux Foundation meeting. You can find the full antitrust policy on the Linux Foundation website. And if you're from an LF member company and you have any questions, you can ask them of our counsel, Andrew Updegrove. If you're from a non-member company, of course, you can ask questions of your own counsel. With the formalities out of the way, we're going to dive straight in because it's a big topic and the audience, the live audience, is pretty big. And as usual, in the OpenChain webinars, we welcome and look forward to questions. In the case of this webinar, you're welcome to ask questions at any point and at the end where we'll have an explicit section for them. At the moment, the people who are live on this call are muted. So if you want to say something right now, use the chat. Later on, as we go into Q&A points and so on, we'll unmute people with questions so they can talk to the speakers. Now, with the formalities out of the way, and I'm sure the GTC team will introduce themselves, but by way of getting the ball rolling, QR code up on the screen takes you to their website, and that allows you to find out all about the firm. It allows you to find out in detail about the people who are going to present today and all the other people on the team. Today we have four speakers. We've got Tony, Shia, Stas, and Whale. And we've had these speakers before, some of them, and some of them are new. It's going to be exciting to see what they come up with. And as I said, they've done this before. They know how this community works. They don't bite. Don't hesitate to dig into anything that they bring up. These people are premier experts in this field, and no doubt they've got a pile of cool stuff incoming. So I'm going to hand over here to our presenters to share their slides and to get the ball rolling.
All right. Well, thanks, Shane, for inviting us, and thanks everyone for tuning in. Today, we're going to explore, aspects of the current legal landscape around AI. Before we dive in, we thought it'd be helpful to start with some of the brief introductions on our side. My name's Tony, and GTC Law Group is an IP boutique law firm. We've been fortunate to, on the one hand, represent several large Fortune 500 serial acquirers in the software and hardware space, as well as many VC and PE firms. And then on the other hand, we represent many startups and mid-sized companies. So we've gained insight from all of them along the way, and probably into the practices of hundreds of organizations, and many of them create and leverage AI and ML. So we're well positioned, to understand the points we'll talk about today from all sides of the table. My practice focuses on AI, open source, patent strategy, and IP transactions. And today I'm joined by my colleagues Wael, Stas, and Shay. Each of them can say more about their practices, so I'll be brief. But before Wael became an IP attorney, he completed a master's and PhD that were both heavily based on machine learning, and he was a research scientist and programmer focused on AI products. Next up in our order will be Stas. After I speak, and Stas was on the team at Amazon that brought us the Kindle. He was formerly the general counsel of Audible, and he ran AI legal at Netflix. At GTC, Stas co-leads our AI group, and he's active in our commercial contracts practice. Today, we also have Shay with us. Shay leads our data privacy and cybersecurity practice, and she recently joined us from Big Law. Shay focuses on tailored guidance on privacy and cybersecurity issues, including regulatory compliance, risk management, security assessments, remediation, security incident response. Hopefully you don't need that advice. And she advised many clients on emerging technologies, biometrics, ad tech, and the key one for today, artificial intelligence. So in terms of the agenda on the next slide, it's pretty packed for today. Well, going to start with an intro to AI and some of the intersections between AI and open source. Then I'll give an overview of the recent litigation, and there's no shortage of it in this space. We'll dive in on a couple of the lawsuits. Then Stas is going to give us an overview of the evolving statutory landscape. And then Shay's going to discuss data protection in AI. So let me hand it over to Well to get started on part one.
Hi all, thank you Tony and thank you Shane. So this is going to be a big topic, and I'll swiftly go through the basic slides initially and then jump into the main meat of the presentation, but happy to answer any of the questions. First here, this is what I will be talking about is intersection between open source and AI. I'll start with how did we go from general artificial intelligence to from AGI, artificial general intelligence, to Gen AI. I will skip open source basics. I think you all know about it, but happy to answer any questions. So what's AGI? It's basically artificial general intelligence. It's about machines that are on par with that. It's about machines that have intelligence that are on par with the humans. They can mimic what humans do. They make decisions, has emotion and comprehension. If you look at the slide, it's basically think about the Terminator, but also the Terminator didn't have any emotion, but you get the idea. And from there, we go to artificial intelligence. Artificial intelligence is narrower than AGI. It mimics human intelligence, but for a specific task. And for that, you can think about language translation, computer vision, autonomous driving. We all know what AI is now. We know these are the applications. And then after that, the main concept is machine learning. And why I say main, because a lot of people confuse between what machine learning is and artificial intelligence. Machine learning is just a technique of artificial intelligence. There are others like logic programming or fuzzy logic, but machine learning gained traction mainly because it requires computational power and data, and we have a lot of them now. And there was a lot of advancement in machine learning, but scientists noticed that we have a lot of data, we have computational resources, but the performance plateaued. So they tried to come up with algorithms that try to make use of the access of data that we have, and they came up with deep learning, and that just peaked. The performance peaked with these machines, and then it gets us to a few years ago to what's called generative AI. You hear about it in the news almost every day. There are new applications. It's basically you can generate. It's capable of generating data such as text, images, video, you name it. One of the most recent one is Strawberry by OpenAI. They say it thinks. I need to go into technicality of what thinks means to see is because the OpenAI is actually they haven't been releasing a lot of information about their systems, but we are probably, if it thinks, then we're probably closer to the AGI than what we originally thought. So let's see what's happening. And then now we jump to the next slide is some generative AI applications. There's not exhaustive list, of course, but basically the most popular ones is you generate text, you put prompt, you generate text, put prompt, generate images, you generate code, generate videos, just as make a scene or basically make somebody speak a narrative. You generate music, how you like the music generated, what type of soundtracks, and you generate synthetic data. And this is especially so for data that scarce, like medical data, so you can generate, and this has very promising future as well. We did a couple of demos, as one using Gemini and the other is using ChatGPT. ChatGPT generate text and Gemini to generate to generate images. And what we did is for ChatGPT, we asked it what's generative AI, and for Gemini, we asked it to generate an image of oil painting of a blue house with a red door on a grassy hill in the style of Vincent van Gogh. And this is the interface, and you see the text on the left for ChatGPT and the Gemini output for the painting that we asked. What's interesting in this, so I mean, you get the idea of what the text and the image generation, but here's the comparison. We did this a few months ago, probably a year, but we used DALL-E instead of Gemini, and now we use Gemini. And you see the result. The results are different, but also they're similar, right? Like they're both the same style. And one of the interesting part is I think this comparison is not true, because basically it's about 1 year apart, and 1 year in artificial intelligence advancements is like ages, probably, based on what we've been seeing recently. Now we jump into this. Basically, there are a lot of AI tools that are licensed under open source. You know that not everything on this slide is for AI, but you can see PyTorch, TensorFlow, OpenCV, Keras, Transformers are all open source, and the licenses are you know about it, like Apache, BSD, GPL. But one of the interesting thing is Meta. They have released their Llama model under what they call open source. I think it's more of commercial like license. It's source available. It's, of course, it's not OSI approved license. It has some interesting clauses in there. One of them is if you have more than 700 million active users, then you request a license. You need to request a license. And the other one is basically you cannot use Llama's output or result of Llama to improve any other language models. So I think these are one of the couple of interesting clauses in that license. And then we jump to the main topic, which is responsible AI licenses. So these licenses are created mainly to allow to use and distribute and curb some unethical use of AI. If you go to their website, you can generate the license. You just pick what you need. You need it for open source code, because it doesn't have to be for open source code. You need it for research purposes and whatnot. And it has been gaining traction. Actually, I was surprised when I was doing my research that AI models under RHEL is more than the number of those models under MIT. And under RHEL is about more than half the number of models under Apache. I think that's great. It's gaining a lot of traction. What's so special about it is basically they have two essential elements. As they call it use restrictions, is to restrict the use of AI technology that prevent irresponsible and harmful applications, and require downstream users to include the behavior, these behavior restrictions that you add. So if you think about it, any license could be RHEL as long as it has some use restrictions, and has the downstream users have these use restrictions. So one of the ethical behaviors that I try to curb is for surveillance. For example, you cannot use machine learning to detect sexual orientation of someone. Computer-generated media, for example, deepfake. You cannot put somebody's face on somebody's body. Healthcare. You cannot, for example, try to use data to find the likelihood of somebody should gain insurance or to get insurance or not. Criminal records. You cannot find the likelihood based on history that that person committed a crime, or the likelihood they will commit a crime, and so on. So these are the main things. And then so one of the things that they have on these licenses web pages is that they also recommend that you have an end user agreement. You grant the users these rights, and you ask them that there are some these use restrictions. Uh, what about it? This has some naming convention. It can be rel for data. It can be for application, which is rel A. It can be for application. It can be for models, rel M. It can be for source code, or you have the combination of them, right? Like for source code and application, you can put it in one name, and they have the name open. They reserved it. Like if I use it, basically open is it's if you use it for open source. So if you use it for open source, that means I can show you from the other slide is here. So if you compare it to others, you see what the main difference is. They have the use restriction, right? And then here the highlighted, you see the rel licenses. It doesn't have to be for open source. It asks you, like, you can probably not have the modification or distribution open, right? So that's why it's maybe. And then if you have the open beside it, then it's for open source. So that's why you have all the modification and distribution as yes, you allow it. And this is an example of an open source. This is open source rel for source code. It's just regular license. The main thing, it grants you the open source rights, non-exclusive, worldwide, royalty-free, copyright to reproduce and reproduce and create derivative works. And the main thing, it has the restriction that we talked about. The main restrictions are the user restrictions, surveillance, computer generated, and healthcare. And it has the regular some terms that you can add, such as violation, the violation and termination and whatnot. And with that, Tony.
All right, so let me dive in on the litigation. And well, you can just flip to the next slide, please. So there's been a lot of litigation against AI, specifically Gen AI providers in the past couple of years. When we first started presenting this topic, we could discuss each of the cases, but now there's not enough time to discuss them all. So what we're going to do is give a litigation overview from sort of like a macro perspective, and then we'll discuss two of the main lawsuits in more detail. We'll discuss the GitHub Copilot case for suggesting open source code, and another one by Getty Images against Stability AI. Perfect. Thanks, Will. So now we'll sort of group the issues and claims, and we'll discuss them thematically. As you'll see, most of the cases are primarily for copyright issues. There are some more cases related to trademark and privacy. There's been even more in other areas, and all these cases are sort of taking their course in the courts, and there hasn't been any very helpful substantive judicial opinions yet. So the copyright cases can be subdivided into four main categories that we'll go through: computer code, images, written works, and music. So let's start with the computer code. So the lawsuits in this area started with the class actions against OpenAI and GitHub/Microsoft, and we'll go over those in more detail. But basically, these tools generate computer code from input prompts. And the common issues in these cases are fraud and negligence are alleged, but the main ones are breach of contract, breach of the open source licenses, breach of the terms of service for GitHub, and then violation of the Digital Millennium Copyright Act. Particularly, there is copyright management information, things like copyright notices and the author that travel with copyrighted works, and you're not allowed to tamper with that. You can't remove it or modify it. So the suits have claims around modification and removal of copyright management information. For image generation, so these are the GAI tools that Wael mentioned that generate images from prompts like Van Gogh, or that image we just had when the rubber hits the road. Here, the cases also evolve around copying and using images for training the machine learning algorithms without the consent of the owner of the image. So the common claims here are direct and vicarious copyright infringement. So basically, claiming that the output is similar to the training data, which is copyrighted. There are the DMCA violations I just mentioned. There's also unfair competition claims. So like the defendant's product uses the plaintiff's name or associated work in a way that lets the product unfairly compete with the plaintiff. And then there's other claims for violation of statutory and common law rights, rights of publicity and unfair competition. And the two biggest cases here are against Stability AI for the Stable Diffusion product, and we'll talk about the Getty Images suing them lawsuit in more detail today. Then Written Works, so this is sort of generating text from for like emails, blogs, and articles. Like the other categories here, the cases revolve sort of around the plaintiff's copyrighted materials for use as training data. Some of the authors, in these suits include Pulitzer Prize winning authors. Sarah Silverman's is in there for her book being copied. John Grisham, the New York Times have brought suits. So it's a bunch of different, all these authors aren't in the same lawsuit. There's a bunch of different lawsuits, and they kind of the claims are around direct and vicarious copyright infringement, DMCA violations, unfair competition. Interestingly, there was a new class action filed against Anthropic in August for training its LLM on content. But in this case, the allegation is that they downloaded the journalist content from pirated websites, instead of, directly from the author's website, or the New York Times. There's another interesting case with the New York Daily News and the Chicago Tribune, where they basically said that the generative AI, experiences hallucinations and falsely attributes inaccurate reporting to the newspapers. So it's sort of the reverse. It's like you're attributing bad content to us. So they're claiming, dilution and injury to their business reputation. The music claims are very simple. They revolve around actual recordings, but also song lyrics. And it's the sort of same thing on copyright infringement and violation of the DMCA. So let's jump to the next slide. We'll talk about the class actions against GitHub. So Well and I covered this in detail last time we were here. So, that recording's still up there. So we won't go into all the details. Again, we'll sort of, give the overview. And not that much has happened. I'll cover the updates here. But in brief, Microsoft and OpenAI got sued for piracy, mainly using open source code on GitHub to train their model. In recent months, the defendants have been winning, and they got many of the plaintiffs' claims thrown out. So the main claims in the case are, the violation of the DMCA I mentioned. So in this case, it's really Copilot removing the copyright management information from the copied code. So that would be taking the attributions and the copyright notice out of the code, or not having them there in the first place, because if GitHub suggests a snippet, there'd be no attribution information there. And believe it or not, this claim was thrown out recently. The court said that the plaintiffs didn't show that their code was reproduced verbatim by GitHub Copilot, so they didn't actually make out their claim. It was interesting because the court sort of read this identicality requirement into the DMCA. I'm interested to see what happens here. Like, I don't think there's an identicality requirement there. Like, the code has to be identical, character by character. So we'll see if there's an appeal on this. But, for now, Microsoft's, winning on that point. There's also claims for violation of the applicable open source licenses. So the code came under the open source license, and you weren't allowed to use it. And then also interestingly, there's claims that OpenAI and Microsoft breached the GitHub terms of service themselves. So the GitHub terms themselves wouldn't allow the data to be used for training. So as an interesting exercise, we looked at the GitHub terms of service before and after Microsoft bought GitHub, and they changed them. After the acquisition, the terms were revised to say that they can use the content to provide the service, but also to improve the service over time was the addition. And Microsoft actually used that in its motion to dismiss the case. So it'll be interesting to watch what happens here. You can see sort of the prior webinar to get more content in this case, but just in the interest of time, I'm going to jump to the Getty Images lawsuit. Yeah, right here. Perfect. Thanks, Will. So this is around the product called Stable Diffusion that can generate images based on text prompts, and it can do the sorts of things described on this slide. In painting, out painting, image to image translation. Interestingly, it was trained on data from this data set called Lion, and Getty Images, their images were included in this data set. And the data set was actually created by a nonprofit organization. And many of the images in the data set are public domain or they're under permissive licenses, like open source licenses, but many are not. So it sort of reinforces the need to be sort of diligent in assessing the training data that you use. Let's just flip to the next slide. So the claims in this case. So the main claims are for copyright infringement. So you can sort of see a result. This is actually from the lawsuit. So you can see the result generated by Stable Diffusion, and you can see the image that was in the Getty Images, stock images that were used to train the model. So you can sort of see the similarities between the Stable Diffusion image and the Getty Images image. There's violation of the DMCA here. Again, it's in respect to that copyright management information I mentioned, but in this case, it's different. Getty Images isn't claiming they removed the watermark. They're claiming they have a deformed watermark. And you can sort of see it there on the slide. As we know, when AI generates images, there's often, an extra finger or a finger missing from a hand, or the letters are malformed. It doesn't understand that it's actually the letter A. It'll draw something that looks similar to that. So you can sort of see that mutated, deformed watermark on the slide there. So, it shows that they did use the images for training. And then there's other claims related to trademarks, dilution of their trademarks, the mark is now changed, and things like unfair competition, because this image generator can now compete with Getty. So on the next slide here, it kind of comes down to this concept of, clean input, clean output. So for almost all the lawsuits, the generative AI providers are being sued for training with training data they're not authorized to use. So what's the solution? Should you as a user, be worried? And I'd say so far, the outcomes from the lawsuits aren't clear. Courts have been dismissing some of the claims, so it isn't great news for the plaintiffs. And the uncertainty maybe could deter other GAI companies, but I actually think, a lot of the companies, can't do what some of the large scale companies can do now. And maybe even these giants, want these suits to go forward so they can sort of steer the law. The Googles, Microsofts, OpenAIs of the world. We haven't seen any lawsuits against users. So that's, important to note. So like the users of the tools haven't been being sued. It's just the providers, of the tools. And a lot of the tools provide, some indemnity. It's important, we have some on the slide from Microsoft and Google to kind of read those closely. They're usually limited by the liability cap in your agreement, and there's various ways, out of the indemnity coverage, if you modify the outputs from the tools. But I believe the vendors are going to stand behind, their tools. Otherwise, people wouldn't, use them. But it's important, just look at your contract. And we're also seeing a movement toward data licensing. So there have been some recent data licensing deals. For example, Google has licensed Reddit's content for like 60 million a year. OpenAI made a deal with the media company that owns the Wall Street Journal, the New York Post, and the Daily Telegraph. And I think it's worth about 250 million over 5 years. So I think some of these problems might just be solved by licensing for large data sets. But on the flip side, for the folks out there, if you have data, it's important to consider your strategy for getting the rights in the data that you may want to license later, because it could be very, lucrative to license clean data to these companies. So I'm going to pass it over to Stas next, but I saw there were some questions piling in, and let me just take one quick
Yeah, I think
look.
some of them are going into the Q&A spreadsheet we'll address.
Oh, okay, we can do that at the end. Okay, because I saw them popping up. So Stas, let me pass it over to you then, and I'll catch up on the questions.
Yeah, thank you. Thanks, Tony. And thanks for the intro in the beginning. As Tony mentioned, I was general counsel of Audible, and I see we have some Audible folks on the line here that asked a
Nice.
question that suggested we made a cut to this presentation that we shouldn't have. This was quite a bit too long for the hour that we had, so some things ended up on the cutting room floor, including cases surrounding voices, and those are certainly out there. We just cut them for time, and I think it's actually a nice segue into the presentation that I'm going to give, in that the issue surrounding voices is probably one of the most longstanding issues, at least, from having been at Audible, in the space. I mean, sound alikes existed long before AI, and there were cases, with just imitators long before AI came along that raised issues of, whether voices, likeness, et cetera. And now, of course, we're seeing this with AI being easily able to replicate a voice with just a few seconds of training data. So the most famous one of them was Scarlett Johansson, when she didn't particularly like the fact that Sam Altman asked for permission to use her voice in ChatGPT, and then they didn't get permission, and they demoed a voice that sounded very similar to her character in the movie Her. That's not a case yet, but may as well be. I'm sure there are talks going on with that right now, but there are actual cases ongoing between narrators of audiobooks and podcasts and AI engines that are able to create voices that they are alleging are sounding a lot like them. So that is definitely another category of cases that is ongoing right now, and we'll be watching closely. And in fact, in the lead-in to the AI regulation, there are also regulations coming out in Tennessee and in California that are very much focused on on this issue. And I think we'll see more of that pop up. So regulation, I think with AI being, the hot topic, it's really at the front of every regulator's agenda. Really a day doesn't pass without reading in the news about a new bill or regulation being proposed or enacted in the US and all over the world. But for the sake of time, we won't go into every possible AI law out there. We won't do a survey, and we won't do a deep dive in any specific law, such as the EU AI Act. That can be multiple hour-long sessions in and of itself. Instead, we wanted to give you a high-level overview on the types of AI regulations that we're seeing, and then provide some examples of those that we think may be most valuable. And the first one, and this is the one that we see most commonly deployed by regulators, not surprisingly, is the application of existing law to the use of AI. If you think about it, it makes perfect sense, since unlike the copyright space, where so much hinges on what is fair use, which you don't know what's fair use until you have gone through the entire litigation and have an outcome, and that still remains very much unsettled, as evidenced by the many cases that we've mentioned. In other areas of the law, it really should be fairly clear. If it's illegal to deceive a consumer about the product you're selling, or to discriminate against an individual based on a protected characteristics, whether it's in employment, housing, lending decisions, or to use their personal information without adequate legal permission or justification, it should be equally illegal to do that when using AI. And that seems fairly obvious, but of course, with the race to adopt AI, we're seeing lapses. And this is sometimes companies not ensuring that they're thinking through all these steps. And actually, sometimes I think they're really unable to ensure that they're complying with the law, because the technology is a bit of a black box. As much as explainability is an important factor, it's not always practically there. So companies are making bets on this technology without being able to do the full diligence that they were able to do when it was more of a manual process. And so some examples that we've seen of enforcement in this area were FTC charging Amazon for using data subject to the Children's Online Privacy Protection Act, COPPA, to train algorithms. Rite Aid was using facial recognition technology as a theft deterrent system in their store, and FTC alleged it was unfair and biased in the way that it detected what was a theft, and so they reached a settlement. There was an order issued to 8 companies in July just inquiring about the services that are using AI to set individual pricing for goods and services. And that went out to companies like MasterCard, JP Morgan Chase, et cetera. And then most recently in Texas, we saw a settlement that involved the Texas Deceptive Trade Practices Act, where a system was able to summarize clinical notes for physicians and medical staff. And they were using that to rely on determining what a patient's treatment should be. And the issue there was, plain old sort of overstating the capabilities of the systems. They issued numbers that turned out, weren't accurate, or they couldn't prove that they were accurate. They overstated the accuracy. They didn't provide enough disclosure on the limitations of the system. And so they basically had to reach a settlement agreeing to be more clear, more conspicuous, and provide disclosures both to users and consumers who are impacted by the use of the technology. So those are, some examples of the current law being used to regulate AI. In terms of broad regulations, which is sort of the next column, and this would be kind of, not really specific to a use case or a specific field. Of course, the most famous one is the EU AI Act. It was initially proposed in April of 2021 and formally adopted in March, and then parts of it have become enforceable in August of this year. And by August of 2027, it'll be completely in force. There are multiple jurisdictions, including Canada and Brazil, that are considering similar regulation, but they're still in very early stages. And in the US, individual states have been enacting various AI laws that maybe are not quite as broad reaching, but are getting close. However, most of them we would be still, I think, when comparing to the EU AI Act, consider industry specific, except Colorado and Utah. Colorado is broadly applicable to the use of AI in providing products and services to individuals. And in Utah, broad disclosure requirements are required when you're using generative AI tools for consumers. It also limits a business's ability to disclaim liability in case they're using AI in a process, which again sort of makes sense. If they're using AI that, to generate a description and it's false and misleading, that's not an out for generating a false and misleading description. Then there are industry-specific regulations. Those included the New York City Automated Employment Decision Tools law, which is targeted at hiring decisions and employment decisions. So everything through the life cycle of employment, from job postings to accepting applications to managing your staff and terminations. And then finally, the use of AI in insurance and government are another couple of topics that have been specifically targeted by laws. And then as a final category, and this is just sort of more of an FYI when you're scanning headlines, there's a lot of policy making kind of focused enactments that are, we should establish a task force to consider or propose regulations. We recognize the importance of AI as a technology, that should be used responsibly. We're establishing a spending program to enable accelerators in the space, et cetera. So all those, of course, are very, interesting, but they don't necessarily have immediate applicability or enforcement. And so when you're reading the headlines every day of new things popping up, I think, it helps me to identify which one of these four is it and how much of your attention does it deserve. So with that, I'm going to pass it over to Shay to speak about privacy.
All right, thanks, Das. So I'm not going to do a whole deep dive into the privacy landscape, but just to kind of give everybody a refresher on what's been going on. It has been incredibly active in the privacy space, and many of these laws do have some provisions that apply to automated decision-making technologies or what they deem as profiling. So right now we have 19 or 20 comprehensive privacy laws. It depends on whether you consider Florida one of those comprehensive privacy laws. But they have effective dates generally between 2020 and 2026. And most of these apply to the personal data regarding consumers. And that is just data regarding an identified or identifiable person. So very, very broad applicability. But in most of these states, the consumer is construed to be an individual that's acting in an individual or household context. So that will exclude most employee or B2B uses of personal data. Now, the big exception there is California, which does apply to both B2B and employment data. There is a kind of complicated overlay and interplay with various other laws where those laws may apply at the the privacy laws may carve out some of these other data types or entities at the data or entity level, but oftentimes companies will be processing data in a non-HIPAA context, for example, and in that case be captured by the CCPA, for example. And then there are various other sectoral privacy laws, like the consumer health data laws that have gone into effect in Washington, Connecticut, and Nevada, several state children's privacy laws, and biometric privacy laws. You also have those AI laws that were mentioned previously. So it is becoming more of that patchwork in the US, not to mention what we have going on across the pond, of course, with the very developed and sophisticated GDPR that is that the regulators have been making clear they expect all of those general privacy protections that apply in any other context to apply in the AI context. Like, for example, the Spanish regulator just made a statement about the use of probabilistic AI in the GDPR context, which is interesting. But we can go to the next slide. We'll dive into that a little bit more when we talk about some use cases that might be interested to all of you. So where do all of these laws intersect with AI? Well, first of all, of course, when there is any processing of personal data, you're going to have data breach concerns. The more personal data that you process, the larger that data breach concern becomes. And of course, when we're doing something like training an LLM, the volumes of data that are used to train that LLM in most cases have to be enormous. So those data breach concerns, the security concerns go up significantly. As I mentioned before, there may be carve outs for the data, but what about if you are combining that data or also using data that is not regulated by another law? Those state privacy requirements would kick in those cases. And there are very, very complicated compliance obligations. For example, a lot of times these laws will require an individual to be permitted to opt out of automated decision-making technologies, particularly if they are conducted solely by automated means without human intervention and create a significant effect on an individual. In that case, a lot of times the individual will be expected to be permitted to opt out of that AI use. And because of the nature of these AI systems, that may be difficult, enable the, for example, the excision of their personal data, but not anybody else's personal data. It could be impossible. Then we have draft regulations that we're expecting under the CCPA, certain use cases, for example, training AI systems is going to be considered high risk. That will mean that there may be certain heightened obligations, for example, privacy impact assessments for high risk data uses, including training LLMs. There are other use cases that may not seem particularly high risk to many of those that are in the privacy space. For example, profiling and furtherance of behavioral advertising, but that is still in the draft regs that could be a high risk use case. In that case, your AI may be subject to certain additional obligations above and beyond those that are just the subject of regular privacy laws. Additionally, in most cases, these requirements are going to apply directly to the controller. But as with many of these tools that were highlighted by my colleagues, they may be used by a different entity and integrated into their technology. So even if it's a situation where your company is primarily a processor of personal data, you may have certain obligations under these laws pushed down to you by the controller, because functionally the controller may not be able to provide that pre-use notice, for example, that's expected under the regulations. Functionally, the controller may not be able to be the one that permits these opt-out rights. So you are probably going to see in both the controller and the processor context, more and more entities, including these provisions in contracts to ensure that those responsibilities are allocated appropriately and understood by all of the parties involved. In many cases, you may know, and as was mentioned earlier in the discussion, these AI laws are meant to protect against bias and discrimination. But in light of the fact that many of these systems are a black box, doing so might be difficult. And then your public representations may come under scrutiny, like in that Texas Attorney General enforcement action that we saw. And so these are all very complicated obligations. Those transparency obligations, you have to make sure that those statements and privacy policies, and even in marketing, the Texas AG pointed out, are correct. And if they're not, you may, even if you're not within the scope of one of these AI laws or the regulations under these privacy laws, for example, you may be subject to an enforcement action based on those state unfair and deceptive acts and practices laws. And so it's something that has to be very carefully considered, even in the development stage, to ensure that these obligations under the privacy laws are you can meet them when a consumer comes and makes those kinds of requests. So we could go ahead to the next slide. And for this one, we kind of thought it would be interesting to consider a common AI use case, and one that crops up a lot of times, in particular in those cases that Tony was talking about earlier, those litigation cases, data scraping to train AI. Now, if we think through this particular issue, what are the risks here? First of all, we talked a moment ago about significant decisions about an individual. If your AI is going to be used to be making a significant decision or creating a profile of a person or training an AI or LLM, typically these laws, these regulations under the privacy statutes are going to kick in at that point. And so then you're going to be subject to all of those heightened obligations, including the transparency obligations. Typically, a significant decision is one that is that creates a legal or similarly significant effect on an individual. So that could be financial or lending services, housing, insurance, education, healthcare, or essential goods and services. And so if you check that box, you're going to be profiling under almost every single one of these laws. Most of these laws require a decision to be without human intervention at all. So if you have some kind of gatekeeping by a human, you may be outside the scope of these laws, even if you are scraping that data from some other source. However, there are going to be other requirements that you may or may not be able to meet. For example, if you are extensively profiling, do you have to provide a pre-use notice? Do you have to provide a notice in advance of the processing operation? Now, many of these laws don't make that clear, but California's new regulations do state that that notice should be before you use the data. So in the case of scraping, is that even possible? Then you get down to issues like, what kind of personal data will be used? Is it going to be considered as sensitive? Now, laws are kind of conforming around a general definition of what's sensitive, and it's similar to what you see under the GDPR. It's going to be racial, ethnic origin, citizenship or immigration status, religious or philosophical beliefs, health or medical data. There are things like sexual orientation or gender identity. And even if you are just inferring these things, the sensitivity of the processing operation will be considered much, much greater than if it's just run-of-the-mill data. Now, many of these laws create exemptions for public data, but a lot of these laws specify that that information can only be considered public to the extent that the individual did not restrict the distribution of that data. So if that person put it out on social media but said, I only want my friends to see it, but then somehow your algorithm still scraped it, then it's probably not considered public under these laws, and it would still be subject to the heightened obligations of these privacy laws, particularly if you're engaging in those significant decisions or profiling and those kinds of things. And then you have the issues that crop up around sensitive issues like images. Are you creating biometric profiles? Are you profiling people for things like theft deterrence? That's a use case that we heard earlier. In many cases, particularly in the EU, the regulators have said that that's just a no-go. We've seen a lot of major enforcement actions around those kinds of data uses. And even if you are sure that your use case isn't sensitive, it's not a solely automated decision that creates a significant effect on a person, are you really able to satisfy the other privacy law obligations? Like, for example, data minimization. Are you able to say that you're only processing the amount of personal data that's necessary for the purpose that you're using it? What about avoiding bias and discrimination? Do you know that that AI isn't using an impermissible factor to arrive at the conclusion? Because that would be something that could get you in trouble. We talked about the pre-use notice obligations. Can you satisfy the transparency? Can you explain the logic involved in your decision making? All of these are going to be significant factors in whether you can satisfy the requirements of these laws. And again, that's why I mentioned that you really want to be focusing on putting these safeguards in place and ensuring that you can ensure the accuracy, the transparency under all of these laws. Otherwise, it will be difficult to justify on the back end. But I see that we have about 5 minutes left, so I want to maybe leave a little bit of time for some questions.
Yeah, we have an insane amount of questions, and I'm going to post them into the chat. And my suggestion is we lean into these questions and we answer them freely, even if we go over time. And people might drop off the live call, but we'll have a recording of this stuff, and I think it's invaluable. Now, I've collected the questions, and I'm going to post them into the chat. What I'd like to do then is read out the first question as an example, and then hand over to you guys to read and answer, if that's okay. The first question that we had in was related to the Llama model from Meta. So the question was the statement, you cannot use Llama to improve any other model. Could you elaborate on that point a bit? And Stas jumped in and said the language in the licenses, quote, you will not use the Llama materials or any output or results of the Llama materials to improve any other large language model, excluding Llama 2 or derivative works thereof. So that was the question and answer that kicked us off. And pretty awesome question. That came from Sandra. Call out to her from ARM. We had dinner like 5 days ago. It was fun.
Nice.
Alrighty, over to you.
Yeah, I think that's one of the clauses in the license that caught my attention is it says that you cannot use it. So probably because one of the new things that's been happening, I think I was reading, you try just to send prompts to this system and collect data, right? So I think one of the things is you use it to train other things. I think that's one of the clauses there that apparently they try to prohibit you from doing that.
They also probably don't want to enable any competition with them, and they don't want to make it easier for you to create a competing, LLM. It's probably a core behind that clause.
Yeah. The second question, Rail makes every license Snowflake. What makes compliance unstable? Yeah. No, okay. Let me read it. Trail makes every license Snowflake. What makes compliance unsellable? Do you foresee the rise of quasi-standard rel licenses where the restrictions are the same? So if you go to the rel website, it tells you, okay, so the main initiative is we have the use restrictions. You have downstream users, they have to comply with these use restrictions and the use restriction that you choose. But I agree with you, is basically it started as very, that's the initiative, but now I can show you it is converging. It's let me try to share this. So I'm just gonna which one? So let me share, like if you go to Hugging Face, so when you do it, when you do the license itself, it starts asking you, how do you, if you have to name it, just like specific name, right? And you see it's been converging here. For example, if you do, now if you check, oh my,
Well, we can't see your screen. I think
you can't see it?
now it's coming on.
Yeah,
Yeah,
so if
we
you
can
go
see it
to
now.
Hugging Face website, right, and then you check for licenses, let's say, so you see some of them, it's converging, right? Like this Creative ML, OpenRL and you see 23,000 models are just under this one. So this one is more just one license, right? But I agree, if you want to create your own, saying, well, OpenRail, I can do that. But I think it has been converging into some of them that are more popular than others. Like this is one. I think Creative ML is the same one that Tony discussed for the Getty images. You see another one like Big License, OpenRail M. So basically, this is another one. This is another one, and this one has like 725. 846, and this was of course the biggest one, like 23,000. So it's right, if you want to add it, just like probably if you think about like Creative Commons, right, you can add it to any license. You can add these use restrictions, makes it different and make every license different. Compliance is hard to do compliance with, but also it's been converging into some of them are more popular than others. Like this one has 23,000 models. I hope like this helps.
Yeah, it's probably like the early days of open source, when we had a bunch of different licenses and sort of people were standardizing on them. So let me hit the next question. Could you provide more information on the negligence standpoint for computer code? So I think this was in relation to the GitHub Copilot case, and I was sort of mentioning the litany of claims that they had in the lawsuit. So the negligence claim is often a claim you'll throw in near the bottom of the list and saying, you know, you were negligent doing all the other things we said. So not only did you infringe our copyright, like you were negligent in infringing our copyright. So it's another way to sort of come at damages in the lawsuits, and also maybe have a different standard, because like a negligent standard might be lower, that you were sort of negligent in doing something. You should have had a process in place for avoiding this. So we can get you on the fact you didn't have a process, which is different than the claim itself. There was also a claim in there for what's called negligent interference with prospective economic relations. So that was also bundled in my shorthand on negligence there. So this was basically like, not only did you interfere with our future ability to make money from our works, you did it negligently. There was also a claim for doing it intentionally. So if you can't get them on, you did this on purpose, you can at least get them on, they did this negligently, they should have known better. Yeah, it was an accident, but you didn't meet the standard of care for doing that. So they're kind of lesser included claims, I'd say, in the lawsuits. I don't know that I would say they're not super important in the lawsuits. Like I don't think they're going to be substantively that interesting. And it kind of ties into the next question, like when will we find out on those claims or any others? So the next question was, are there any timelines for these lawsuits? When will we hear further outcomes? So there's no certain timeline. I think it's going to be years. If you look at similar, let's say, litigation, Oracle v. Google, APIs, copyrightable case, it took 10 years to get that through the court system all the way up to the Supreme Court and get like a final decision. So I don't think any actionable law is coming anytime soon. Like the way this will likely play out, maybe we'll get one decision and it'll be in, one circuit. and then we'll get a different conflicting decision somewhere else. And it's probably going to be, 5, 10 years before there's some, body of law that we can actually rely on. Again, it sort of comes back to the problem with law. It often is playing catch up with the new technologies that are coming out. We'll probably see, statutory guidance before we see, really good outcomes from these lawsuits. So short answer, I think it's going to be years and years before we get, something useful out of these cases. All right, the next question, Stas, this one's probably for you,
Yeah.
right? This is,
Yeah, I can take that one. I mean, I think in the case of, so if I understand the question correctly, it's that Australia and New Zealand were ahead of others on regulating online trust. Is it the same sort of for AI with the EU catching up? And I think the answer is no. EU sort of has clearly been the one most willing to get ahead of the issue and regulate, and that's not without some criticism. There were concerns both in the process of like negotiating the final text by various member states as to whether some of the regulation might dissuade investment in AI companies in Europe and cause companies to choose other jurisdictions to pick their home base at. Is it going to stifle innovation, et cetera? And it's why I think we haven't seen carbon copies of the EU AI Act in other jurisdictions, just yet. Because there is like this concern, are they kind of getting way ahead of the technology without knowing enough and trying to regulate it? And is it going to be harmful to innovation? But yeah, I think right now, clearly EU is way ahead of everybody else.
all right, I guess, Shay, the next one's for you. It even has your name.
Yes. Okay, I have the question related to what you are discussing. Are there emerging takedown actions for AI tools or resources when critical or damaging problems or issues are found? And we've got a parenthetical, e.g., online trust and safety regs can require immediate takedown within 30 minutes globally. So what we see in the AI space is very similar to what we see in other spaces. And I think I mentioned previously that the Spanish regulator has recently weighed in on the use of probabilistic AI. And they said that it could be compliant with the GDPR, but given the GDPR's requirements for accuracy and transparency and all of the issues that we described, they kind of doubt how lawful the use of probabilistic AI would be. And so basically in the AI context, what you'll see is that a regulator will, in particular, this particularly applies to the EU, that the regulator will identify an item or a requirement of the GDPR that a particular technology is not complying with, and they will either issue a fine, commence an enforcement action, or the worst case scenario is a stop processing order, is what they typically call it. And they just say, stop processing all of the personal data for this purpose. One of the more recent ones we saw was a stop processing order for Meta for behavioral advertising, because the regulators said you can't rely on consent because the consent is not specific and granular enough when you're talking about these behavioral advertising marketplaces where you have real-time bidding. The person can't even know who they're consenting to have their data processed by, for example. They can't know all of the parties in the processing chain, and you can't rely on a contract because the contract isn't with the data subject. And so they said, just stop processing. And so similarly, we were seeing like a number of complaints were issued against X for their Grok tool, and it seemed like behind the scenes, X was scrambling with the regulators to arrive at an agreement before they were ordered to stop processing that said, okay, we're not going to use the EU data to train Grok anymore, at least right now. And then maybe they'll roll out like a consent method. Yes, I agree. You can use my data to train Grok in the future, but they had to come to an agreement with the EU regulators. Otherwise, they probably would have gotten one of those stop processing orders.
Great.
If I may add one more thing to actually the recent crop of California legislation has some takedown requirements for deepfakes. So yeah, that
Oh,
that
yes,
very
that
interesting.
may be coming.
Yeah.
Great. And I think the next one was a comment. I think we hit it. It was interesting that synthetic spoken word is not in the list. Example, Scarlett Johansson, like voice use. So Stas mentioned that on our list. And then the last comment here is also an interesting potential sidebar in education context. Tools used by faculty to detect AI use in submitted written work. Bias in tools that produces false positives for non-native English speakers, resulting in failing grades and reputational damage. Yeah, like I think that's a real concern. I think it comes back to use of all these tools. Like you have to watch them when you're using the tool to make a decision, as opposed to informing a decision made by a human. So ultimately the faculty should make the decision on is what is being flagged a false positive, and needs to own that decision. It's not that you're just relying on the tool. I'd say on the student side, it's really hard because, like, what do you do about that? Like, that looks like that use case would be ripe for a class action lawsuit, on behalf of a bunch of students against one of the vendors of the tools. But absent that, there's really no meaningful way for any individual student to, go, take down a tool provider or seek recovery on, what's happened. They probably wouldn't have, the resources or the timelines, to do something like that. But it's all, important. I think that's also why a lot of the regulators and lawmakers are taking these kind of things into account, to build protections in. Maybe we'll see something similar to deepfakes, in the academic context.
Yeah, and Tony, that's actually an interesting thing that the draft California regulations are trying to hit upon, because they're trying to encompass not only solely automated decision, but also automate decisions where the automated decision making was a significant factor in the decision-making process. So even if a teacher said, well, I mostly relied on this, but I used my judgment in the end, that still is probably a legal or similarly significant effect, like the one that the commenter described. And if the teacher turns off their own decision-making authority and mostly relies on that tool, then it would probably still be within scope of the regulation.
Yep. Great. I think we hit them all. Thanks to everybody who was able to stay, and I know some other folks will probably tune into the recording. And Shane, thanks very much for having us.
Oh gosh, yeah, no, this has been amazing. You covered a lot of ground. You've done more time than we booked, and that's 4 lawyers, so that's a fortune right there.